we lost my voice a little bit yesterday, so sorry about that, Judge. But I believe we do have to deal with one subject, Your Honor. I noticed in here in the courtroom, there is a camera. While I understand there may have been an application filed at some point, I've not seen that application. It's not been given to us as counsel. I don't know about the state, so we've not had a chance to deal with that. I will, based on my recollections, at least at this point, recall that there is an order previously in this file which bars cameras from the courtroom. If I remember correctly, it was early on, probably around the prelim or thereabouts, entered by Judge Standard, which either barred or severely limited.
Check that out, and then I think there was a request made a long time ago, like in 23 or something.
And that may have been the one that
I'm not sure where it's at. I can look at that real quick.
Yep. I think we have to, if that's the one, unless there's a new request, if that's the request, I believe Judge Standard put restrictions on that. I don't have that because I was not aware they were going to be served, so I apologize for that. We were downstairs on the first floor, that's why I'm presuming it was probably a preliminary hearing. I believe we did it back then on the first floor.
Who's the date?
February 7th or 8th, 23. February 8th, sent a letter. I don't think I was on the case, and it said sent a letter to Judge Vansel as the chief judge. And you did file a response to the request to contact. Same date. State response in favor on that same date.
look back, there may or may not be an order, it may be a docket entry. There's not, we don't obviously have a transcript at this point in time, but as I recall, as I said, it was dealt with on the spot. By Judge Stevens.
The docket entry said the audio device recording was at this time. On February 8th.
The audio device recording. So, the way it looks to me, if everyone's on the same page here, is that the request was filed on the 7th. On the 8th, there was a response from both sides. And then the court granted the audio device recording only. Like I said, that was just standard, looks like, and I don't see that there's any motions since then. Is that what everyone's seen as well?
Yes.
Okay. So it sounds like 2.5 years ago, it was just audio recording only. Yes, no cameras per previous ruling, but if you have audio recording, then you are allowed to do that, okay?
Okay, would I be able to just point it at the ceiling so I can record the audio on here?
I don't have any issue with that.
I can just leave it kind of like that.
Can you tell that there's a ceiling so that there's no visual and audio, because I assume this camera, your camera and audio work at the same time.
Yes.
I just remember, I was sitting there, and it was a totally different equipment on that day. It was much smaller camera, as I recall, and I just recall Judge Standard, it was like, don't go near it. No disrespect. It was like, don't go near the camera. You know what I mean? Yeah, as long as there's no, I don't care if there's, as long as there's no audio, visual recording. I don't care. You point it to the ceiling.
It'll be fine.
Anything else we need to address? No? Okay. Let's go ahead and go back on the record, 22 CF 491. People of the state of Illinois, v. Marcy Oglesby. A continuation of bench trial. The only matter that came up over the adjournment was that there was media present in the courtroom. The parties discussed this prior on the record. It looks like there was a docket entry made on February 8th that granted audio device recordings only to the day prior to that ruling. There was a request made for extended media coverage, and the state filed a response in favor of that. The defendant filed a response to request that no media coverage be allowed, and it looks like Judge Standard made that ruling at that point that there be audio only. So for a full record, there is a camera in the courtroom. The media outlet has assured the court that the camera is not pointed in a direction where it would be able to record anything of further value, but they would use the camera for audio recording purposes as well. And all parties are aware of that, have agreed to that, and will move forward at this point. Ms. Warby, any witnesses or evidence for the court today?
First of all, Your Honor, I would move for the admission of Exhibit 16A and Exhibit 16B pursuant to Illinois Rules of Evidence 8036 and 90211. 16A is a document that is 1,308 pages, so we'll be submitting that in digital formatting only. And it will be referenced as a litigation packet from NMS Labs. And then I have printed out a hard copy of the first 30 pages and marked that as 16B. The reason being that the first 7 witnesses today are testifying by Zoom, and we don't have the ability to put up documents on the screen while they testify, and it will be referencing these first 30 pages.
We have no objections, Judge.
Thank you. And, are you asking these be admitted into evidence as well at this point?
Yes, I'm moving for admission of them into evidence.
Then, without objection, exhibits 16A and 16B shall be admitted to evidence. And you may call your first witness when you're ready.
I called Tram Wen, and she will be testifying via Zoom under the name of Sherry Kusenko.
Hi there, Ms. Nguyen, are you able to hear me?
Yes, I hear you.
Perfect. Okay. So I have Ms. Nguyen present via Zoom.